Okay, good afternoon, counselors. We're here this afternoon on the case of Dollar General versus Choctaw Tribe, case number 45-7683. See, both sides are represented by counsel. Is counsel for petitioner prepared?
Yes, Your Honor.
Excellent. Counsel for respondent prepared?
Yes, Your Honor.
Wonderful. Counsel, you have 10 minutes. You may now proceed.
Good afternoon, Your Honor, and may it please the court. My name is Letson Douglas, and I represent the petitioners in this case, Dollar General Indulgent Corp. At this time, I would like to reserve 1 minute for rebuttal.
You got it.
Dollar General requests that this court reverse the decision of the Fifth Circuit in order to uphold its due process rights guaranteed by the United States Constitution. The controversy in this case involves a dispute over the scope of tribal court jurisdiction. The respondents, the Mississippi Band of Choctaw Indians and some of its members, argue that the Choctaw Tribal Court has jurisdiction over Dollar General, a non-member corporation. We respectfully disagree. The cause of action involves an alleged tort committed by the manager of Dollar General's store on the reservation, a non-member, against a tribal minor. We argue that the tribal court does not have jurisdiction over this matter and that it would be improper for 3 reasons. First, this court has held that there's a general presumption against tribal court jurisdiction over non-members. This presumption should be upheld here in order to protect Dollar General's constitutional rights. Second,
I don't think, Counselor, either side disputes the fact that there's a presumption, but isn't this really about whether or not one of the Montana exceptions apply?
it is, Your Honor. Both sides, as you mentioned, acknowledge the fact that over the past 30 years, the court has identified a strong presumption against tribal court jurisdiction over non-members, regardless of if criminal or civil. There are 2 exceptions to this laid out in United States v. Montana, and we argue that it doesn't fit into either of these exceptions either.
Do you think that both exceptions are before this court?
No, Your Honor. The respondent does not argue that the second exception, that if a matter implicates tribal sovereignty, they do not argue that this applies either. The district court said that it is not applicable, and that issue is not in front of the court here today.
Okay, great. So let's focus then on the first exception, if you would. Why doesn't that apply?
The first exception, as laid out in Montana, allows for tribal court jurisdiction over non-members through if there's a commercial relationship, or as this exception has come to be known, a consensual relationship. And this relationship over time has been found to exist if there's a dispute over taxes, over fishing and hunting license regulations. And we argue that...
Well, that isn't the case here, so...
That isn't the case here, yes. And so, because this dispute isn't centered around a tax issue or another regulation, we argue...
I think the language in Montana, yeah, we do talk about taxes, but there's this other means. So I don't think either side would argue that a tort is a tax. So let's put that aside.
Sure.
I don't think any side would argue that a tort is dealing with hunting or fishing, so let's put that aside. But I think the real question is a tort an other means? And I would assume you would say no, but why?
Yes, we would say no. And the reason is because this exception is really focusing on business relationships. Dollar General doesn't deny that it had a consensual commercial relationship with the tribe. It had a lease agreement for its store at the Choctaw Shopping Center. It agreed to participate in this tribal youth opportunity program. We don't deny that those relationships existed. However, this exception, as outlined by this court in United States v. Montana, was designed to allow a tribal court to assert jurisdiction over disputes that arise out of those commercial relationships, and this dispute did not arise out of that commercial relationship.
But you mentioned the lease. Doesn't the lease say that the Dollar General subjects itself to tribal jurisdiction? Is there a choice of venue clause in the lease?
Yes, Your Honor. Dollar General.
So why shouldn't we honor that?
We should honor that in regards to disputes that arise out of contractual disputes.
Mhm.
If this case was regarding the fact that Dollar General wasn't paying its agreed upon, monthly rental fee, yes, the tribal court here would have jurisdiction. If the dispute arose out of, the fact that Dollar General was not abiding by, different health standards, yes, that's another issue that could have come out of that contractual relationship. However, this was not that type of dispute. And in
But
fact,
for the lease, but for the yacht, you wouldn't be here. So isn't there a relationship there?
again, we're not disputing that there's a relationship.
Well, I guess maybe I shouldn't use the word. Isn't there a nexus there?
We would argue that there isn't a nexus, that this could have happened anywhere,
Mhm.
and that one of the points that the court has emphasized is that, and it did so in Plains Commerce, is that a non-member defendant must be able to reasonably anticipate being held into a tribal court. And this is due to the special nature of tribal courts as opposed to U.S. federal and state courts, that the laws are unfamiliar, that the form is unfamiliar, and that
But why should that matter? If they've consented to it and there's a nexus, doesn't that, does due process, and it seems like you're sort of talking about due process, does any of that even apply if they've consented and we find there's a nexus?
as I said before, Dollar General consented to being held into court for disputes that arise out of its contractual agreement. That's not the case here. When it signed that lease agreement, Dollar General could not have anticipated being held to court over a tort claim. And because of that, it would be improper for this court to allow the tribal court to assert its jurisdiction.
Is your position that neither of the Montana exceptions apply if the issue, the tort, or the issue before the court doesn't impact tribal sovereignty or tribal self-government, or is that a separate analysis?
Your Honor, in Plains Commerce, this court narrowed the two Montana exceptions, and as you're referring to, is that in that decision, the court made it clear that if the consensual relationship itself doesn't implicate tribal sovereignty and tribal self-governance, then that consensual relationship shouldn't give rise to tribal court jurisdiction. And we abide and encourage this court to continue to follow that decision in Plains Commerce.
Does Oliphant apply here?
Oliphant, the general principles in Oliphant apply here. Oliphant.
Do you know of any case law that specifically says that we don't extend the logic of Oliphant jurisdiction to civil cases?
Your Honor, the case law that the majority of cases do the opposite. In U.S. v. Montana, it said explicitly that that Oliphant's rule that tribal courts should not be able to extend jurisdiction over non-members in criminal cases should extend to civil cases as well. And a number of cases since then have followed that. Plains Commerce, Nevada v. Hicks, and because of that, besides the two exceptions that allow for courts to tribal courts to exercise jurisdiction over non-members, the only other way would be through congressional delegation, and that's something that Oliphant really focused on. That Congress, the United States Congress, can grant tribes jurisdiction over non-members, criminal or civil jurisdiction.
Okay. I see you have about 30 seconds, counselors, if you'd like to sum up.
Yes. So, because Dollar General could not have reasonably anticipated being hailed into court over a matter involving tort by its manager, this court must uphold its constitutional rights and its right to due process. And
Is there any indication that there was any due process violations in this case?
Your Honor, up until this point, the entire dispute has centered over whether or not the tribal court should have jurisdiction. We haven't gone into the actual alleged tort.
If we decide that the facts here support finding that the first Montana exception does apply, do we have to get into the due process?
Yes, Your Honor, because in that case, you would be allowing the tribal court to have jurisdiction over Dollar General, which is a non-member. The tribal court, while it may resemble a United States court in many ways, does not afford its defendants the same.
So consent and a nexus that has an impact on tribal sovereignty and self-government. If you find all of those things, then there's this sort of fourth prong, does it violate due process? So finding all those things isn't sort of a waiver of due process.
No, Your Honor.
Okay.
However, as I said, if this case was about the fact that Dollar General wasn't paying its rental fees, then it would have reasonably anticipated being hailed into court for that, and that would be proper. We're not arguing that we're not asking this court to do away with the Montana exceptions. We do believe that there are instances when a tribal court should be able to exercise jurisdiction over non-member defendants.
So what you're saying is if the Montana exceptions are met, then that can still violate due process.
Let me backtrack. I would like to argue that if a Montana exception is met, the court would be able to have jurisdiction.
Okay, thank you.
Thank you.
Okay. Counselor, you have 10 minutes. You may begin.
Good afternoon, and may it please the court. My name is Matthew Carr, and I represent the respondents, the Mississippi Band of Choctaw Indians. Mr. Chief Justice, the specific issue before the court today is whether the Choctaw Tribal Court may properly exercise civil adjudicative authority over a Dolgen Court as a means of regulating the activities of non-members who have entered into a consensual relationship with the tribe. In other words, this court must decide whether the right granted by Montana's first exception to regulate the conduct of non-members in a consensual relationship includes judicial enforcement of torts committed by that non-member against a tribal member on reservation lands. The Fifth Circuit Court of Appeals held that tribal jurisdiction over tort claims was proper against non-member Dolgen Corp under the first Montana exception.
Well, we're familiar with the Fifth Circuit decided, Counselor. Why did they get it right?
The Fifth Circuit got it right for several reasons. First, they hinged on that the purpose of the Montana exception was to protect was to provide tribal regulation over non-member conduct on tribal land when that conduct was the result of having that non-member allowed access to the tribal lands, which is a very important aspect. It's a basic concept of fairness and one that the court recognized when they created the first Montana exception. Dolgen Corp's relationship in this case with the tribe gave rise to the tort claim at hand, as the claim was the sore.
Which relationship? Which Dolgen Corp relationship?
Well, they had two consensual relationships with the tribe. Their first one was through their business licensing and leasing on the tribal land.
So I don't think the other side disputes the fact that there were consensual relationships, but
Right. Well,
how is there a nexus here? How do those consensual relationships have anything to do with the tort? Doesn't it say in the lease agreement that the jurisdiction is only valid as to claims that arise from disputes around the lease?
Yes, Your Honor, that is correct. The relationship that does have a logical nexus to this tort claim is Dolgen Corp's acceptance of a youth through the Tribal Youth Opportunity Program.
So the lease, we don't need to consider that.
We can set that aside.
Okay. So your argument focuses on the YOP only, the lease, not a consensual agreement that satisfies Montana.
We argue both in our brief, but we can, I think the more important one to focus on is the Dolphin Corp.
Okay. So let's do that. That sounds good.
So, would you like me to expand on why that, the last
Yeah,
one
yeah,
is-
the YOP. So you wanted to talk about the YOP.
Yeah, so, well, I guess going forward to, 2008, when this court decided Plains Commerce Bank,
Mhm.
they really illustrated the point of this logical nexus between the consensual relationship and the, regulation. So in that case, they actually denied tribal adjudicative authority over a tort because the non-member bank, had been alleged of discriminatory lending practices from their sale of land they owned in fee to another non-member,
Mhm.
which this tort arose out of the bank's general dealings, which did not implicate the relationship that the bank had with the tribal member, the Long family.
Mhm.
But in this case, we have,
But didn't Plains also focus on this idea that the court shouldn't take jurisdiction unless not doing so would somehow harm tribes' inherent authority and ability to self-govern?
I disagree with that. I don't think it limited Montana's exception to that. I think the limitation it placed was more on it more stated that there needed to be a logical nexus between the relationship of the non-member with the tribe and the regulation being sought to enforce.
Mhm. Well, we don't have a regulation here, do we?
Well, we have judicial enforcement of torts.
Is there a difference for our purposes between regulatory jurisdiction and adjudicative jurisdiction?
For these purposes, I don't think so. I think this court has said in cases such as Strait that the adjudicative jurisdiction is directly related to the regulatory jurisdiction, and because.
So would you argue that if we were to find that the tribe has regulatory jurisdiction over these matters, that it by necessity would have adjudicative jurisdiction?
So long as that adjudicative jurisdiction is related to that legislative jurisdiction, which is what I think Plains Commerce Bank was actually touching upon, which is there needs to be a nexus between the consensual relationship and the regulation, not necessarily that the consensual relationship implicates tribal self-governance, which I think is actually inherent in the second Montana exception.
Mhm.
And
Clearly.
I don't think.
But is that before the court?
No, it is not before the court. But I think it's just, I bring it up to mention that if Plains Commerce Bank did limit the first Montana exception to only consensual relations that implicated tribal self-governance, the second purpose.
Well, let's say we accepted that.
Yeah.
Could your side still prevail?
I believe so.
Why?
I believe that the tribe's general ability to adjudicate tort claims involving torts against one of their members from a non-member is of utmost importance to tribal self-governance. And again, part of the reason and the rationale behind the first Montana exception, which is that if a tribe allows non-members to conduct business or activities on their reservation with their members, they can be subject to their regulations.
Well, let me ask you about this due process question. If we find that Montana is satisfied here, one of the exceptions, the first exception, since that's before the court, do we need to get into whether or not due process issues are implicated?
I don't believe so, because I've
Doesn't due process apply to all U.S. citizens?
Yeah, yes, it does. But I believe when this court decided Montana, they had taken those considerations into account,
Mhm.
and they specifically carved out an exception where jurisdiction or regulation was proper over a non-member. If there did turn out to be, which there's no evidence that there was any due process violation, those due process violations would be of concern to the court,
Mhm.
but on an entirely separate matter concerning the due process violations, not jurisdictional. So I'd like to also mention that petitioner has alluded to these due process right violations, and that the Choctaw Tribal Court is not there's allusions that they're not a court.
Counselor, why do you
competent
think we
jurisdiction.
decided in Oliphant that tribe should not have jurisdiction over non-members in the criminal context?
Well, Oliphant, as you mentioned, is a criminal context, which
Mhm.
is a completely different scenario than civil context. With criminal context,
What were we worried about there?
well, we're worried about the deprivation of a U.S. citizen's life and liberty. Not
Well, aren't we
just-
worried about the same things here? Aren't we worried about the deprivation of Dollar General's $2.5 million? Isn't that property protected?
That's property interest. That's not doesn't carry the same grave implications as
Mhm.
personal being taken to jail
Mhm.
or worse. There is that distinction between criminal and civil, and
Can you point to any other distinctions between that, just besides money's different than liberty? That's okay.
I think that's the main distinction.
That's okay. Keep going. It's fine.
So back to due process. So there's actually a statute, 25 U.S.C. section 1302, that binds tribal courts to uphold all U.S. citizens' constitutional due process rights, and that in itself is a protection that would ensure if there were due process right violations, there would be a remedy in U.S. courts.
Okay. You have about 30 seconds, Counselor, so if you'd like to wrap up.
Well, just to wrap up, I would just like to mention that Dolgen Corp explicitly signed contracts that set the tribal court as the exclusive venue of litigation, and for this reason, along with other reasons, there's no reason for them to act surprised that they're being hailed into tribal court. And I think it's very fair and reasonable, considering that the Choctaw Tribal Court is a sophisticated tribunal in the year 2015, which is a competent court. But to conclude, this court should uphold the lower court's judgments and allow the Mississippi Band of Choctaw Indians adjudicative authority over Dolgen Corp as a means of regulation.
Thank you, Counselor. You have a minute.
I would just like to make one point, Your Honor. The respondent alluded to the fact that even if this court goes forward with the Plains Commerce narrowing of the Montana exceptions, that it would still fit into those exceptions because this ability to enforce tort actions against non-members is so important to the very fabric of the tribe, and we disagree with that point. First, the district court already determined that the second Montana exception does not apply in this case, and the respondent does not dispute and did not dispute that in its appeal to the Fifth Circuit.
But don't they say, generally speaking, if the tribe can't adjudicate tort claims, then essentially that impacts the government's ability to function? They can't force.
We argue that it doesn't affect the.
How should we look at this, generally or specifically?
Specifically, and.
In what way?
Well, I think the way to look at this is to look at Oliphant.
Mhm.
Yes, it's criminal, but in this, spectrum of, civil to criminal with contract disputes on one end of civil and criminal on the other, a tort is more in the middle, if not, closer to the criminal side. And that in Oliphant, the court determined in that case that tribal jurisdiction over non-members in criminal cases is improper because of the risks that defendants face. And this tort action is similar to, and it could have been a criminal case. And for that reason, the narrowing of the rules from Plains Commerce should not apply.
Great. Thank you, Counselor. Appreciate both sides making arguments today. The court will take this case under advisement and issue a decision in due course.